Richard, 39 years old, math teacher and defensive coordinator. Christina, 53 years old, math teacher. Mason, 14 years old. Christian, 14 years old. On September 4, 2024, at Apalachee High School in Winder, Georgia, those 4 people were killed, and 9 more were wounded by a 9th grader with an AR-15 style rifle his father has given him for Christmas. Last week, both of them were sentenced. I want to walk through what the court decided, and then I want to talk about the part that matters the most to all of us watching this. The 15 months of warnings that came before September 4th, and what we are supposed to do differently. Cole Gray was 14 years old on the day of the shooting. He is 16 today. In late July, he pleaded guilty to all 55 counts against him, including 4 counts of malice murder. No trial, no plea deal that kept his exposure, a straight plea to everything. Because he was 14 years old at the time of the offense, Georgia law took the death penalty off the table entirely. That left Judge Nicholas Prim of Barrow County Superior Court with exactly 2 options: life with the possibility of parole, or life without the possibility of parole. He held a 3-day sentencing hearing where survivors testify, families testify, investigators and mental health experts testify. And what came out of that hearing is the part I want you to understand, because it's not what most people assume about the 14-year-old school shooter. The defense presents a genuinely bleak childhood: substance abuse in the home, physical neglect, 3 kids in an environment that state's child welfare officials themselves corroborated. That is real, and it's not nothing. But the persecution presents something else. Messages going back to 2023, more than a year before the attack, laying out plans for a mass shooting, a documented fixation on Columbine and on Sandy Hook, participation in an online subculture that treats mass murderers as celebrities. And then they play the jailhouse phone call. In those calls, he compared his own notoriety to other attackers. He talked about being in the big leagues. The judge fine was blunt. He told Gray his crimes reflect, and I quote, permanent incorrigibility. He told him, "You are raked with guilt. You should not be proud of yourself. Life without parole on each count of malice murder." Gray declined to address the court. He showed no visible reaction. The judge says, "I have spent a lot of my career around threat assessments, and permanent incorrigibility is not a phrase a judge reaches so lightly, especially about a 16-year-old. Now the case that actually changed everything. 2 days after his son was sentenced, Colin Gray, 55 years old, was sentenced to 15 years in prison. Back in March, a jury convicted him of all 27 counts, 2 counts of second-degree murder, 2 counts of involuntary manslaughter, 18 counts of second-degree cruelty to children, and 5 counts of reckless conduct. The jury deliberated for less than 2 hours. Understand what that verdict represents. Colin Gray is the first parent in the United States convicted of murder in connection with a school shooting committed by his child. We are seeing parental accountability cases before. James and Jennifer Crumbley in Michigan after the 2021 Oxford High School shooting. Also a gifted firearm. Also a child invisible crisis. But those were involuntary manslaughter convictions, with a top 10 years by each parent. The defense here asked the judge to use Oxford as the benchmark. The judge went past it, and the reason he gave is the reason I'm making this video. Colin Gray did not pull the trigger. He wasn't there. The judge says so directly. None of it happens if Colin Gray doesn't carry a rifle into the school. But the judge laid out a list of things the father could have done and did not. He could have locked the guns up. He could have kept ammunition out of the house. He could have moved the firearm somewhere else entirely. He could have gotten this son into counseling. And then this line, which I do ask every school administrator and every parent watching this to sit with. He was convicted. The judge says because the warning lights were flashing brighter and brighter, and he didn't get his son help, and he didn't remove his access to guns. The judge added that if there has been guns locks or the ammunition have been out of the house, Colin Gray will have no being standing in the courtroom. 18 years on each second-degree murder. 15 years on each second-degree murder count. Here is the part of this case that keep me up at night. It have nothing to do with either sentencing. On May 2023, 16 months before the shooting, 3 users on Discord report an account making threats to shoot up a middle school. They reported to the FBI. The posts include photographs of firearms. The account name referenced Adam Lanza, the Sandy Hook shooter. The FBI traced the IP address to Jefferson, Georgia, and it passed it to the Jackson County Sheriff Office. On May 21st, 2023, an investigator and a deputy went to the house. They interviewed the father, they interviewed the boy, who was 13 at the time, called the nights making the threats. Colin confirmed there were guns in the house and says they weren't loaded. He talked about taking his son hunting and get him off the computer. The investigators' report noted the boy present as quiet and calm. The information was deemed inconsistent. It could not have been substantiated. There was no probable cause to arrest, and the FBI noted no further action was available at the local, state, or federal levels. At trial, that investigator testified that he took the father and the son at their word. He made one follow-up call the next day, and that was it. And that was the end of it. 7 months later, Colin Gray brought his son the rifle. Now, this is the thesis. I want to be careful and fair. Those deputies did not have probable cause. They were legally constrained. I am not staying here saying they should have made an arrest, because they could. But that is exactly the point. Threat assessment is not a criminal investigation. They are 2 different disciplines with 2 different standards. And when we collapse one into the other, we get September 4. A criminal investigation asks, can I charge the person today? A behavioral threat assessment asks a completely different question. Is this person on a pathway of violence? And what do we have to do to put it in place to move them off it? Nobody was asking the second question. There was no multidisciplinary team, no school notification that carried forward when he transferred district, no case management, no follow-up at 19 days or 6 months or a year, no monitoring plan, no conversation with the father about access to weapons. That was anything more than a doorstep chat. And unsustained tip was treated as a closed tip. So let me give you 4 tips for administrators, for school-based officers, and for parents. Tip number 1, a sustain is not unfounded. If law enforcement cannot charge it, that case doesn't disappear. It hands off to your threat assessment team. Someone owns it. Someone's review it on a calendar basis. If a tip closes and nobody owns the person afterward, your process has a hole in it. Tip number 2, information have to survive a transfer. This kid moved districts. He moved counties. Records of concern have to follow the student, and the receiving school have to actually receive them, not just technically be able to request them. Tip number 3, access to weapons in a school safety question, not just a household one. Every credible threat assessment protocol asks about weapons access. Ask it, document the answers, and when the answer is yes, and we hunt together, that is not reassurance. That is a data point requiring a plan. The court just told us in the cleanest terms available that a lock and a separate ammunition supply were the difference between two outcomes. Tip number 4. Parents are now unambiguously inside the accountability perimeter. A jury took under 2 hours. If you are parent of a child in crisis, secure the firearms. They get the counseling and document that you did both. That is not legal advice. I am not an attorney. It's what the case records now shows the standards to be.